There you go. I almost forgot. Welcome, everybody. We will get started in about a couple of minutes or so, just letting everybody sign in. Thank you.
Fred here. You can't see me. Oh.
Hi, Fred. Welcome.
Hi, guys. Sorry I'm late.
No problem. We're just getting started in about a minute or so. I'm just giving everybody an opportunity to join us. There's quite a bit of RSVPs today, so I want to make sure everybody is able to join us. It's a couple of minutes.
Okay.
Thank you. I'm going to go ahead and mute everybody for now, and then I'll unmute you. Feel free to unmute yourselves to ask questions and so forth. We'll get started in 2 minutes. Welcome, everybody. Those of you that just joined us. We will be starting in about a minute. Thank you so much. Welcome. So welcome, everybody. My name is Fernando Parra, and I have the great privilege of being an assistant professor of accountancy at the Craig School of Business, where students prepare to become the next generation of bold, ethical business professionals that will be leading us into the future. I also have the pleasure of serving as the director of our Institute for Family Business, which is a comprehensive resource center for family business in our community, as well as a nexus to connect with our amazing students. It's part of our mission to serve as an educational and resource center. We are offering this webinar in collaboration with Terri, Hilliard, Olson. We certainly appreciate the West Coast Industrial Solutions Magazine and the Fresno State Alumni Association for their assistance in promoting this event. We're also grateful to the IFB Advisory Board, a lot of you present today, which is chaired by Sam Guile. They all have worked very diligently to make our resources available through the time, efforts, and contributions, as well as the rest of our members whose contributions make this webinars possible. So please stay connected with us for more information on the resources for your family business. If you'd like to support our mission, become a member, just visit www.fresnostateifb.org. I'll be sending an email as a follow-up after this webinar. So now on the subject of Proposition 19. Proposition 19 takes effect this February 16th. And if you plan to pass your home, your vacation homes, or your rental properties to the next gen, this new Proposition 19 will severely impact your options. So what does that mean to you and your family and your family business? Today, we have the great privilege of hosting a speaker with very impressive credentials who's going to give us some guidance on this newly passed rule. Terri Hilliard Olson is the principal of Terri Hilliard PC in Westlake Village, California. Her practice centers on advanced state and business succession planning, asset protection, special needs trusts, and family protection planning for seniors. She's a private mediator focused on helping families, elders, and individuals and other businesses resolve through family meetings and, if needed, mediation. She earned her law degree from Loyola Law School in 1989. She's certified as a dementia care practitioner and as a veterans accredited attorney. She's a frequent speaker at community and professional events and offers her own series of seminars on elder care and state planning issues on a monthly basis. She publishes articles on trending topics, state planning for seniors and individuals with special needs called Terri Talks. And she updated and republished her first collaborative book titled Protecting Your Legacy, What You Really Need to Know for the Second Half of Your Life, that focuses on family mediation and aging. Also, she published companion books entitled You're Not Alone, with focus on dementia and Alzheimer's diagnosis for those diagnosed and caregivers. So let me turn it over to Terri. Welcome, Terri. It is all yours.
Thank you, thank you, thank you. Very nice to meet all of you virtually. And thank you, Fernando, for allowing us to talk about an issue that I don't think anybody is an expert on, because we don't know what the future brings. We know that there's a proposition which was very, what I'll call cursory and unclear, and we're trying to pivot like we have with COVID. We did a COVID pivot. Now we're doing a Prop 19 pivot, unfortunately, for our families to see what do we get to do here. So I'm going to do my best to share my screen. And I think I did it. Everybody see that?
Perfect. Thank you.
Yay. So I love definitely the COVID pivot, and everything's by video these days, right? So let's see here. What do we want to do? So what does Prop 19 mean to me and my family? I think it's really clear that the proposition was voted in on November 3rd, and it was narrowly approved. My understanding is that the largest group that supported it were the realtors, and they have a very strong organization. And there really wasn't a whole lot of opposition. And I think that was probably unfortunate, especially with COVID and things of that sort. I think it may have been under the radar, unfortunately, because it does affect our families. So the amendment has three components. One is it allows homeowners over 55 that's severely disabled or disaster victims to purchase a new residence and port over their property tax assessment from a prior home. Also, the replacement home can be in greater value than the adjusted assessment for the replacement home, which was interesting because that is a big change right there, because we had a cap. And then also we can change homes and port it, meaning move up to 3 times during our lifetime within any county in California. So that's effective on April 1st, 2021. And that was really the lead to the proposition. We want to take care of our seniors and fire safety, disaster victims, right? And the other components really relate to how are we going to pay for that. Next, the second component was that it limits the applicable parent, child, and grandchild exemption from property tax reassessment to properties that will be used as the recipient's personal residence. So that's a big change, and we'll be talking about it in a moment. And for example, an inherited property that we may use as rentals, for instance, it's no longer available to port over to our family members. So for instance, there was a big hullabaloo, if that's the right term for it, and publicity about the Bridges family, where they inherited the property from their parent, the surviving parent in Malibu. They have a beach house, and the property tax is approximately $5,000 a year, but the rents are $15,000 a month. So they're pushing these trust fund babies get all of the perks, and what about the rest of us? So everybody's got their different view on that, but that was one of the, I think it was actually in the bill talking about trust fund people and those that inherit. And then also transferred properties not used as a primary residence will be reassessed at the market value upon transfer. And so that could be vacation homes, rental homes, second homes. So if you inherit or they're transferred to you during someone's life, that's a transfer for many different reasons, and that will be reassessed to the fair market value. So that family cabin or the like will be reassessed 100% on the date of death. And the last portion of the proposition is talking about the additional revenue earned will be used for fire protection and to reimburse counties who have losses in property tax revenue. So that means that if there's a loss from somebody going from a downsizing to a maybe more rural county from a more urban county, many of the tax revenue is lost to the burden on the new county. So that's where the money comes from, and that's where the money will go to support that. Next, why is it really relevant to all of us? Well, you or a family member may own property that you intend to leave to your children and then your grandchildren, or you may be that child that may inherit the family home or the family cabin or the rental property that your parent got from the grandparent, etc. So these I call legacy properties. So we want to know what the law is so we can act appropriately and see if there's anything we need or can do. Also, your estate plan will not work as intended without acting now, or at least getting the right information. So that's why we're all here. That's why it was a big pull, because we all want to know, what does it really mean to all of us? And it may not be relevant, so we can at least decide, oh, it's not an issue for me. Also, the vision and focus will now change as to when we give properties, what we give, and what kind of taxation there might be. And we have a short window to act. The portion with the reassessment related to residences and non-residence properties that we want to transfer is a very short window. It's actually February 16 is when the law is in effect. So we have a very, very short window. I want to give you a little background, because many people go, what does this really mean, and how could they do this, and what have we done in the past? Well, California is unique in that under Prop 13 in 1978, and I'll just admit that's when I graduated from high school. I don't remember Prop 13 being a big deal, but I remember something in the news. Howard Jarvis, kind of a funny, quirky kind of guy, but he made a big difference for a lot of us. And so in 1978, there was a limitation on a transfer tax and assessment of 1% was the limitation, because, and then any increase in reassessment had to be 2% or less for future years. And what apparently was happening from 1974 to 78 is we had different counties and cities could just levy taxes on our properties without kind of the free reign. And I'll say that they didn't really adjust to the fact that properties increased in value in that 4 years by 80%. So don't quote me on that, but that's what I understand, because I was a little bit younger then. But that made a big difference. So if your property increased by 80% and they said, oh, you know, this year is 10%, you might be priced out of your home. And especially for seniors back in that time, that would be problematic. So Prop 13 was passed. There's nothing like it that I'm aware of in any other state. But we also have a very large income tax burden. So we're taxed in different ways than other states for that matter. In Prop 58 in 1986 created the parent-child exclusion, and Prop 193 in 1996, so soon thereafter, what was it, 10 years after, there's a grandparent-to-grandchild exclusion, but the only distinction there is the parent must be dead. So it has to go, there has to be no one in between those two. So it allows a grandparent, and it goes both ways, by the way, parent-child, child-parent. Same with grandchildren and grandparent. Prop 60 in 1987 allows those 55 and over to port their current property tax base to a new residence within the same county with a fair market value cap. So it has to be that amount that you sold it for or under, and is actually expanded by Prop 19. And so that's where the Prop 19 is adjusting that. And then Prop 90 in 1988 expanded to other counties, but then it was optional for the county to adopt it. So only 7 of the 58 counties would allow you to transfer your property tax to another county. So that limited people from moving closer, quote, to their closer to their family members. And that was part of the proposition. Going, wouldn't you want Granny to go move close to the kids? You know, so it's actually, we'll talk about that in a moment, but it's actually to any county anywhere in California, which is a nice addition. So property tax is really levied by a county assessor's office to the owner of record of real property. This is not an estate tax, it's not an income tax. It is literally a county tax to pay for services and the infrastructure, I'll call it. And we have extra taxes for education, as we all see in our property tax bill for those who are fortunate enough to own property. The basics for property tax, the basis is your purchase price plus your improvements, plus any Prop 13 increases over the years, that 2% we just talked about. And that's how you would determine that. So we're going to be talking a bit about how do we determine what my basis is and if this is really a concern for me later. So property tax basics, reassessment. You're reassessed if there's a sale. So there's a transfer by sale, transfer by gift during someone's lifetime, or at death. So we call that inheritance. That was the focus of the bill. So some people thought it was only when it was inherited, not when it was transferred during lifetime or gifted to our kids. It applies to everything, apparently. So we don't need that example. We're going to get to the goodies. Property tax basics, also documentary tax transfers. Some of your counties will have transfers tax on top of that. So anytime we do a transfer, we're going to pay another fee. Exclusions, common exclusions. So if I transfer my property to my spouse, that is an exclusion. There's no reassessment. Parent-child under the present Prop 58 and the new Prop 19, no reassessment under the certain limitations that we're going to talk about. Grandparent-grandchild on Prop 193. And if you're over 55, that moving to different counties is under Prop 60 and 90. If you're original co-tenant, a co-owner with someone, there won't be, when someone passes, there's not a reassessment, thankfully. And maybe you might use, some of us have used LLCs or other entities to hold real property. And so there's certain limitations, but there may not necessarily be if we do it right, a reassessment on transfer of portion of the interest. That's just kind of a background. So spouses may transfer property between them without reassessment. That includes community and separate property. So some of us have things we've inherited that are separate property, and we want to look at that. There shouldn't be any issues. Also includes death of a spouse. So that's not going to have a reassessment. And note that same-sex spouses, registered domestic partners may be entitled to the same relief. So we need to make sure that we raise our hands when we want to take good care of our loved ones. Okay. So Prop 19's goals. This is really a revenue bill. We're looking for money. We think it started out with, oh, it's really nice for seniors and disaster victims. They could do that anyway. They just needed to have a way to pay for it. And this is not the first time this type of bill, I think it was Prop 5, that was proposed and lost because there wasn't a way to pay for it. And so it was defeated. It provides dedicated revenue to wildfire relief, which is great. At least I think so, based on the revenue from the limitations on parent-child transfer. So it comes directly from that. And we're going to see a lot of different changes that we don't even know about, how the assessor is going to calculate what our new taxes are, and from this new revenue, I believe. So there may be more limitations. So a lot of people are acting now before there's the change in the law. The alleged goals, that sounds pretty cynical on my side, but it is a little bit. The alleged goals of Prop 19 is to limit property tax increases on your primary residences by removing unfair location restrictions. So that's moving county to county, anywhere in California, on homeowners who are severely, and this is from the actual bill and proposition, on homeowners who are severely disabled, victims of wildfires or other natural disasters, or seniors over 55 years of age. And that's interesting because I never think of myself as older, but 55 apparently is the cutoff point. So I'll take it. If it benefits me, I will take it. I like my discounts. Yeah, I work with that. I just love it when they say, oh, you don't really look that old. So I just turned 60. I'm just going to put it right out there. So I'm happy that I have options. And so and it says here that, 55 years of age and older that need to move closer to family or medical care or downsize, find homes that are better fit their needs. I think a one-story is probably a good idea for me, but sooner than later. Or to replace a damaged home and limit damage from wildfires on homes through dedicated funding for fire protection and emergency responses. So that's exactly what it says in our Constitution. There's a lot in there, but there's a lot that's not in there, right? Does it really tell us what it's going to do? Not really. So we're going to have the assessors flesh it out for us. And I'm not really confident about how that's going to look. But anyway, that's Terry's version of the world. So Prop 19 alleged goals continue. They're limiting property tax increases on the family home used as the primary residence. That term is really important, the primary residence. So you have to take it as your primary residence. And by protecting the right of parents and grandparents to pass on their family home to their children and grandchildren for continued use as a primary residence, while eliminating the unfair tax loophole used by East Coast investors. I'm not sure I know many of those, do you? But I guess they're out here. It seems important to the drafters of this proposition. Celebrities got a bad rap that day. Wealthy non-California residents, okay, people moving in the area, and trust fund heirs. That might be you and I, by the way, because most everybody has a trust in California, right? And we If you own property, you should have one. If not, I'm going to lecture you later about that, just to protect it from probate. But we do pass on things through our trust. And I don't know that's a trust fund, baby. We'll talk about that in a moment. And to avoid paying a fair share of property taxes on vacation homes, income property, and beachfront rentals they own in California. So again, that example of Lloyd Bridges leaving the property to their family members. And, you know, it's pretty rough with Malibu house, all paid for, $5,000 property tax. I know mine at home is a little more than that, so it is a little annoying. And, you know, renting out for $17,000, $18,000 a month. There you go. So some people were upset about that. Parent-child exclusion. So what the rules are now until February 16, 2021, that's the cutoff for this portion of the bill. Anything related to porting over your property tax on a new home if you're 55 and over, and disaster victims or severely disabled, that is April 1st of this year. This one, right before Valentine's Day and on a holiday weekend. So everything has to be done much earlier. So how about that? Very, very generous. So according to the Proposition 58, which is the parent-child, that's effective in 1986, which we talked about, the transfers between parent and child may be excluded from reassessment. That's what we were talking about, what it was before. That's an exclusion. So when we transfer or we die and give it to our kids, then there's no reassessment if they file a certain Prop 58 form where they raise their hand and say, I want that exclusion based on that proposition and that law. What's important for some people to know is that children of a spouse are included. So it could be my stepdaughters. So they don't have to be biologically connected to me. They would qualify. Also, as the spouse, I qualify. And so it goes steps, etc. So it's kind of a more inclusive. So if my husband's parents left something to my husband, he could also leave, she or he could leave it to me as well. I am considered a child. Limits. Right now, you can give your home an unlimited value. So if I lived in Palo Alto and I had a $4 million home that I bought for $25,000 way back in the day, I can leave that if I died before the 16th of February, which I don't plan to, but if I did, or if I transferred to my family on or before that date, then I can leave the entirety of that value, like the Bridges home, you know, let's say that's a $5 million, maybe $10 million property, wholesale goes to them. So that's an unlimited primary residence, but that's my home. And we also have the privilege of $1 million of assessed value of any other property. So if we had rental properties that have very low assessed value, because it only can go up 2% every year, then we can give, that's what we look at, the assessed value, not the fair market value, but the assessed value. We look at that and we can actually port that over to our family members, only our children or grandchildren if our children are predeceased us, and move the real property tax to them. So we've all been under the impression, if this hadn't changed, that we could leave through our estate plan any rental properties we may have inherited or acquired, and our primary residence to our children. And we would get a step up in basis, and we can talk about that later, but they get the fair market value, the date of my death, and they would get the low property taxes. And most of us would like to have that privilege continue, but it will be ending to some degree on February 16. And if we forget to share that Prop 58 assessment, we have 3 years at present to file that form. That was pretty generous. So I'm going to pass that up because I'm going to leave more time for questions. And the grandparent-grandchild exclusion, same, unlimited primary residence, and 1 million of the assessed value for that property. Any other properties, non-residents, like maybe a cabin, maybe a rental home that we grew up in that our parents left us, a rental home, a duplex, you name it. And that again, if we raise our hand to get that exemption, we have 3 years to do so, not immediate. We should do it immediately. We don't want to run out of time. However, beginning in February, on February 16, and everything has to be done by the 12th, and I hope it's done by the 31st of January, because we know that the county recorder and the assessor, like many of us, are all working from home. So I think the assessor here in Los Angeles and Ventura County are a year behind on their Prop 58 processing. So a lot of people are getting reassessment notices and, oops, sorry, we found it, didn't realize. So it's a very upsetting, but if we do it right, stand our ground, we're protected. We're all doing the best we can. So the exclusions, the transferor, so that would be me and my example, must take the homeowner's exemption and must be the primary residence. So if I can only give now my primary residence to my, let's say, child, parent-child in this instance, but I can no longer do that $1 million of assessed value properties. So any rental homes, those will all be on the time of my death or at any time of the transfer that I might give them to my family, to my kids, totally reassessed. So actually, that frees me up to give rental properties to maybe a friend that I like better than my kids. But I'm just kidding. I love my kids. I have 4 beautiful daughters, and they're all adults. They're very nice most days, and they're going to get it. Not to worry, Margot, you know, she's listening right now. So also the transferee must take homeowners exemptions within 1 year. So they're cutting us off. We cannot be lazy in using our exemption. And this is constitutional, by the way. When we do these propositions, we amend the Constitution of California. Also, exclusions from reassessment is limited. Let's see. So what did we lose? It's an unlimited primary residence exclusion that we lost. So it's going, and we're going to talk about that in a minute because it's going to be limited. And the transfer of non-primary residence property without reassessment, that we lose. So any rental properties or extra properties, vacation properties. We're also going to lose any $1 million exemption in a bypass trust. So we are going to talk about that. So talk to your estate planner. So if your spouse passed away and you're using a bypass trust, there's some reassessment when it comes out, unfortunately. So we need to talk about that. Sometimes you can swap out properties, but don't listen to me. Get advice from your estate planner. And these also apply similarly to the grandparent-grandchild exclusion. So what does this really mean? The requirement, if we are going to be able to leave under Prop 19 to share our property during our lifetime or at death after February 16, it's limited to only the primary residence. That's it. So it has to be your family home. It can't be a rental that your child decides, oh, I'm going to use that one. It has to be the primary residence of the person that died or the person that transferred, the owner at the time of the transfer. Must be able to take the homeowner's exemption or disabled veterans exemption, which is important to know. And the land only included to the extent necessary for the primary residence. So for instance, let's say we have a family farm and we have maybe a vineyard or the like. the primary residence, it's going to be limited to the necessary property. How is that defined? At this point, we have no idea how that's going to be defined. I don't know that it's going to be a generous definition. And spouses cannot have separate primary residences. I've had many families call me and they go, oh, well, we don't need to live together anymore. So I'm going to live over here and you live over there, sweetie. And we're going to give we're going to deem the primary residence, we're going to give it now. And so that doesn't work. I have very creative clients, clearly. And I have to say, I thought about it myself. And then also, we talked about the bypass trust. So that's a trust that was formed when one of the spouses passed that holds property and may be reassessed. So the new property residence exclusion. So this is a new formula. So not only is it limited to the primary residence, but we're also limited as to the value. So as we talked about earlier, the Bridges were able to give the Malibu home. So I'm just going to speculate. Let's say it was worth $10 million back in the day at the time of death. Lovely. And that's unlimited. There was no limit as to the value. It was unlimited before. Now, so it says here, the old $1 million rule for non-residents, well, you have to look at it. So we look at it and we say, if the assessed value is $400,000, so you look on your property tax rolls, and then you say $400,000 is less than or equal to 1 million. So you look at that, then then the entire property avoids reassessment. So they look at, you get a $1 million grace, and they look at the assessed value of what you inherited. And if it's the 400,000 is less than the 1 million, you're safe. There's no reassessment. The new rule is you calculate the calculation to determine applicable reassessment if the fair market value minus the assessed value, so AV is assessed value, is less than or equal to 1 million, reassessment is avoided. If the fair market value minus the assessed value is greater than 1 million, then there's a partial reassessment. So the maximum you get generally is about $1 million. So they have this funny, well, don't tell them I said this, a funny calculation, and I think formula. You take the assessed value, you add the fair market value, you subtract the assessed value minus the $1 million, and then anything above that calculation is reassessed. So example, the assessed value of a property is 500,000. So you look at the property tax roll, not the fair market value. And the fair market value is 2 million. You say the fair market value minus the assessed value is 1.5 million, which we see that it's greater than 1 million. We take the 500,000, that portion that's greater, plus 2 million minus 500,000 minus 1 million fair market value, this is 1 million. So the new assessed value is for that second $1 million. So the maximum you can port over, I call it, is the value is about 1 million. So that might make a difference for those that are going to be maybe staying in the home. Because number one, you have to use it as your primary residence. And number two, it's limited. So it may be reassessed and the family may not be able to stay. Might not be cost effective. The reason for this revenue, why it's a revenue bill, is it's encouraging sale of properties when people pass. End of story. When it's reassessed, we relook at everything and we say, you know what? We are going to make this an opportunity for the realtors to come in and share. Also, there'll be properties, the argument is that properties will be available for sale, and maybe properties, the values won't go up so quickly because there's more available for sale. So potential Prop 19 solutions. We can give an outright transfer before the 16th of February. You can give to your children, take your Prop 58 or to your grandchildren if it makes sense under the other proposition. There's no parent in between. You can straight away gift it and transfer it before that date. The problem is that what if that's a rental property? Because right now you can give an unlimited residence value and also up to 1 million of the assessed value. Remember the assessed value, not the fair market value of other properties. So many times, many of our families are living on those rents, for instance, on those other properties. And so that makes it difficult for cash flow for our families. So how does it affect us? Maybe our parents won't be able to do that. They look at the property tax, low property tax as being more important than the rents. So if my mom gave me a rental property, I will now be taxed on that income too. I mean, it's a blessing to have it. I realize that, but I might be at a higher tax bracket than she, and she needs the money. And if I need to gift it back to her, there are a lot of the gift tax issues there. Other advantages though, is it's simple. We're done. Transfer, done. We get their parent-child, and we just kind of push it down the road. And then disadvantage is if parents remain in the primary residence. So let's say, I'll use my mom as an example. My mom transfers her property to me because the real property tax is, let's say, $2,000 a year. And that's something that our family thinks is important to share. If that's the case, arguably, and she still lives in it, I need to charge her rent. Otherwise, there might be some phantom income if I ever got audited. Also, if there's a transfer straight away, the downside is there's a loss in the step up in basis. So that's going to carry, the basis is going to be carrying over to me. So if she bought it, let's say the fair market value is 500,000 and she bought it for 150,000 years and years ago, then that basis of 150,000 plus any of her additions to the property minus depreciation is moved to me. So I stand in her shoes. And if I need to sell the property later on, I don't get the step up in basis that I would have gotten had she given it to me through her estate plan at her death. So that is a big deal. And you know, it's important to realign our trust planning to make sure that if we do some gifting, to realign it. So if we give our son Oscar a house and we didn't change our estate plan, it gets confusing for the family member. Sometimes it's just not fair either. And if Oscar wants to give cousin Shirley, or let's say sister Shirley, part of that property afterwards, that's a gift and there's a reassessment there. So it's not as easy as we think. Next, the over 55 exclusion. So we talked about until April 1st, we can port over our tax basis. We are limited to, we have a ceiling as to the value of the property that we sold, and we're limited to only certain counties. So a lot of people are appreciating the fact that if you think that you're going to keep your home and live in it for a very long time, or you might sell it and move to a different county in California, or just out of state for that matter, we don't want to do any of this extra planning. We'd like to be able to port it over, because you can't have both. You can't give it to your kids and then say, oh, now I'm going to use Prop 19 to the other portion of it, and I want to port over my low property taxes to a different property. So that's not going to work. It's one or the other. We also must purchase until 4/1, we have to purchase a replacement dwelling within 2 years. That's the cap, which is the equal or lesser value, which is hard because a lot of times properties are more expensive. And there are certain allocations as to the fair market value assessment over time. Next, beginning in April 1st, which is the portion for the Prop 19, porting your property tax over. Again, it's 3 times that you can do that. And right now you can only do it 1 time. Now it's throughout California. Before, we only had 7 counties. And many of them were pulling out of that opportunity because they didn't want the lower taxes coming to them. And it protects victims of wildfire and natural disasters. So many of us know people that have had that situation. So we also want to protect our special needs individuals. I do a lot of special needs planning. So some of this is really important to our families. And the only, what I'll call inconclusive portion of this is that we don't know if the sale, you have to buy, you'd have to for sure buy after April 1st to get in a county that didn't offer this before, but it's unclear whether the sale of your property and the purchase of the new property had to be within the same, after April 1st. It's unclear. So I have a lot of people who just sold their property and they'd like to go to a different county. So they're waiting to April 1st to buy the new property, which is great, but I'm not really clear that it's going to work. I think it will, but I don't have a crystal ball, and not always are our assessors, worried about what Terri needs. Instead, it's about their revenues and how they see the law. So now there's no cap on the net value. You're just on the new value of the property. It just might be assessed for anything above that. So there might be a little bit of a bump. So if you bought a property that was, $500,000 more, that $500,000 would be subject to reassessment, but the net number may still be really palatable for you and getting the home that you want, because it was really limiting people to that cap, and then it was not applicable at all. So there are certain things that people are using to remedy or act beforehand. And it may help us even after this law is in effect. So when we worry about our parent-child exclusion, when it's no longer available to us under certain circumstances, maybe rental properties, we could very well use entities to share partial ownership, because in an entity, an LLC, for instance, there are lots of what I'll call rules around it, but there's no parent-child exemption. But there is if there's a change in control, then, or if there isn't a change in control, that means that, let's say we gave our children 10% of a property, but we didn't give them more than 50%. So let's say we gave them up to 49%, we can transfer that, but that is not a reassessable event. So some people are using entities and different arrangements to gift to their children, or anyone for that matter. It could be, it doesn't have to be parent-child, because there's no parent-child exemption rules related to LLCs. So you have to look at the change in control rules, because if it changes more than the original owner has, let's say 50%, someone has 51%, the entire property, whatever's in there, is reassessed. So we have to be very, very careful. Make sure you talk to experts on that. So again, parent and child transfers never apply inside an entity. All right, what do you do now? What should we do now? Well, you need to evaluate the residential property you or your family own. You look to see what the fair market value is. You look to see what the assessed value is. Look at the 2021 assessor rolls on your property tax bill. You get to see that. Then, or maybe it's your parents' property that you want to look at, check it out. It's available online. It's easy to see. You just need the address or the APN number. And what is the property tax now? And if sold or transferred, what would it mean to my family if there was no exemption available? So that rental property, would it go fair market value? Would it triple? Would it quadruple? Is this a taxable estate over the estate tax exemption? If so, you're going to be doing something a little bit different than if your family did not have a taxable estate. Right now, individuals can leave $11.7 million individually to our family members at passing or gift. At this point, a lot of my families are gifting that amount because we believe it's going to change in the near future. Also, we want to see, is this really a family legacy property? Is it something that we want a dependent family member to use in the future? So sometimes you want to plan to make sure that our child, for instance, can afford to live there. Many times we have special needs trusts that will own properties that we want to keep it, the property tax bill low so that we can make sure that it's they're able to stay. Also, the family farm is included but limited to the area necessary for the primary residence. We can talk more about that. It's not clear, but it has been noted. And what do you need to do? You need to really talk to your attorney or your CPA to make an informed decision. So for my clients and my families and new families, we look at the fair market value, the assessed value, the property tax bill. Is this a legacy property? Do I have a taxable estate? Do I need to do some tax planning, or is this something we need to do now? Do we have rental properties? And that's what you need to know in order to go to an expert and really kind of hash out what to do. There are some resources I have here that you can actually look up the rules and the legislation. That's important. And I think many of us right now are using some trust planning, and it's irrevocable gifts that have ways to attempt to make sure that there's a step up in basis, that we have actually a parent-child exemption is preserved, and rents can be passed through potentially to, let's say, the transfer, or maybe it's the parents or grandparents. So there are ways to do it that we're working with our families on. But if you're going to do that, we have a very short window. So make sure you reach out to your advisors, or if you need any help, let us know. I'm happy to direct you. And I will be happy to provide my slides to Fernando, Dr. Parra, to make sure that you can go, oh my gosh, it's so much information. Very much a lawyer, right? Everything's in there. So I'd be happy to share that. I'm also going to share, if needed, Proposition 19, the letter to the assessors that came out on December 11th. That's actually on one of these resources that I have on the screen. But if you go to the boe.california.gov and look at property taxes or Prop 19, you'll find this is like the hot letter that I will say summarizes the rules and where there's big gaps. There's going to be a lot of fuss. Some people say, oh, it's going to be overturned. I don't know about you, but I don't feel very comfortable relying on something happening in the future and hoping. We are doing planning right now, anticipating that we won't have, there's no do-overs, I will call it. I don't know about you, but not many do-overs in my life, right? So we have to plan ahead before we're thinking for our families and our businesses.
Terry, if I may use this as a point to interrupt, there is a few questions out there,
Yes.
starting with how do we claim these exclusions, right? The exclusions to be able to be exempted from that reassessment. Do we have to proactively contact the county upon somebody's death, in this case, a parent's death? Or do we wait for the first prop tax bill post-death? I realize this may...
That's a really good question, because, you know, do we raise our hand? Do we not? Right? they know that usually, as we all know, if you've had someone pass in your family or your friends, that the first thing that comes out of their check and their bank account is Social Security, right? If you don't live to the end of that month, they pull it out. So they know when you're dead. However, you have a responsibility to advise. And if you want to raise your hand for an exclusion, as we know now, if they passed or the transfer occurs before our deadline in February, we have 3 years to do a do-over, I call it. So there's a Prop 58 form with the assessor. That's absolutely imperative. If it's after that, we have only 1 year. Otherwise, it goes, so sorry. So we have to be proactive. It's absolutely imperative. So when someone passes, and if they have a trust or otherwise, you really should get some estate or trust administration done, even if it's just, let's say, lodging the will with the court that stops creditors, for instance. Those things are important. And if there's real property and there's a parent involved and a child as a beneficiary, you want to definitely raise your hand.
Thank you, Terry. What if you received a home from a parent in 2016, but the title of the home is still in the administrative trust, i.e., it hasn't yet sold, and you haven't yet changed the title to the new name or the recipient of the home? How will Proposition 19 impact the situation? So the parent died in 2016, and the home is still in administrative trust, so it hasn't sold and it hasn't changed. How does that affect Proposition 19?
Well, I would definitely, number one, it sounds like you're planning on selling it, but from the date of death to the date of transfer, there should have been a reassessment if we didn't file our Prop 58 exclusion. So it's really important before it gets crazy in the new the new version of Prop 19. They looked at the date of death. So the date of death, the new Prop 19 will not affect this. It just, you may be reassessed or have to fight over it. So you're going to want to do that transfer or that sale and make sure that the Prop 58 form, because you have 3 years to do it still under the old law, because in 2016, the present law is effective. It's really important not to be unclear, because if they figure it out, you're going to get a property tax bill or go back to the date of death and then go, oh, pay it. This is what I found, is if when they find out and there hasn't been a Prop 58 processed properly, they will assess you, then require you to pay the back taxes. Then the Prop 58 will be analyzed and managed, and they go, oh, I'll give you money back. So you're loaning their money to them, the assessor. And none of us want that, because it can be very, very expensive. A reassessment is a huge number. I would definitely, you can even, with the administrative trust, they may have done a Prop 58 anyway. So you might look to the attorney to find out if they may have done that at the time the trustee changed. So you may have already done it.
Wonderful. So it sounds like some important dates are coming up, as you mentioned. Would they be able to send your record? Yes, we'll get recordings and slides going by tomorrow. So, I'm gonna have to edit this video a little bit, and then I'll go ahead and share with all of you. And can you schedule a Zoom meeting within the next few weeks? So I'm assuming this question is for Terri and her availability.
Not Fernando?
Not me. Not this time.
You know, at this point, we are totally inundated. We need to talk yesterday. So we have some spots open on Monday, because the sooner we talk, if you can have the fair market value, the assessed value, what the, if it's a legacy property that we want to keep it after a parent passes or the like, those are the important things. And we could have a quick call, just go, you know, what are the rules and what can we do? Because we're starting to pack up because there's such a short period, but I'd be happy to help. Thank you. Absolutely. My number is right there on the screen.
Wonderful, Terry. Another question from Wei. I'd like to hear more about the LLC part. Do the children need to be added to the LLC to avoid reassessment? I don't know if that was properly understood. So, do the children need to be added to the LLC to avoid reassessment?
So if we are using the LLC to hold property, the parent in this instance, assuming, you can actually, the parent could give it to anybody, but let's say our intent is to give it to our children as an alternative. There's no parent-child exemption within that. There are just rules as if you change control, meaning over 50%, you gift to a child, there'll be 100% reassessment. So you're able to give member interests, gift it, for instance, in some instances, or sale to other members of the family. So you're going to gift, let's say, 20% to your son, or 20% to each of the kids, and there won't be a reassessment. There's no parent-child exemption, but there are ownership control dynamics that determine whether or not a property will be reassessed.
So is that 50% or more, a change of 50% or more on the ownership there?
Exactly. So if someone gets 51%, boom. So original owner has to keep at least 50%. There are techniques in which we create that entity, give shares or member interest to let's say 49% to our kids. And I'm not giving advice, but some people will move it out and then move it back into a different entity to give more interest. So you have to make sure that you're talking to counsel and your accountant to make sure things are done properly. So there could be step transactions over time gifting where we use several entities.
Wonderful. If we have 3 rental properties and we don't transfer to our children before February 16, we would have potential protections against reassessment by transferring portions, percentages as irrevocable gifts? And that's a question.
Any transfer after this February 16 as to that proportion will be reassessed.
Even if it's a gift, an irrevocable gift in portions or percentages.
Mm-hmm. Absolutely. So what we're doing now is that's why we're gifting on this side of the date. And we're using, sometimes we call them defective trusts, where the owner, the grantor, the creator retains certain rights. So it's part of their estate, but for property tax purposes, it will be a completed transfer to a sole beneficiary, which is parent-child, so we can use our Prop 58 exclusion, because for rental properties, we have that $1 million of assessed value, but it's going to be gone. So anything after February 16, if you give part of a rental property, not necessarily in an entity, but straight away, I'm transferring this 1/3 or, my $15,000 worth, right, for an annual gift tax exclusion. All of that, every one of those would be a reassessment as to that proportional interest. So if you have rental properties that you or a family member wants to keep in the queue without a reassessment upon your death or later transfer, you really need to look at it right now. Otherwise, you just know that it's going to be sold. Yes, ma'am.
Can you hear me?
Yeah.
Yes.
Okay, that was my question, because I just finished I do trust for everybody else. I just finished doing ours. And then I saw this, I have 3 rental properties in our trust. Now it's making me think about redoing my trust now because.
Well, maybe it's not redoing your trust. It might be creating a different type of trust.
Okay.
Before the February, before
Yeah,
Valentine's
exactly.
Day. Before
But
Valentine's
basically
Day.
before tomorrow. That's what I feel like. It's just right here.
I know I created stress for you. You have until,
no,
let's
that's
say,
okay. That's
Valentine's Day.
Yeah, I know. So that's what makes
Um,
me think we plan on staying in our primary residence. So I'm not really too concerned with that. And the value, I don't think we're in Madera County. I don't think we're gonna have anything over $1 million for our home. But now it's the 3 rental properties that I'm worried about. So,
I think it's really important to look at that. Most of us are saying, yeah, will our kids, I think the determination is, will our children, or do they intend to sell
Mhm.
at our death? And they need to sell quickly because it'll be reassessed as of the date of your death.
right.
So it goes
Okay.
boom, up, and there's no exclusion, there's no delay in that.
Right.
And if they will sell, likely, so it's not a legacy property that we want to
Mhm.
keep in the family forever and ever, fourth
Right.
generation, then I wouldn't worry about it. As to your real property for your home, if you think that you wanted to stay in the family,
Yes.
then you have that cap also. Let's say $1 million for rather than that silly calculation, but we know we can calculate it.
Yeah.
And not only that, is your child has to live in it.
Correct.
So
Okay.
most
Yeah.
of us have our own, thank God, have our own houses and may not want to be in the family home. So that will all also be sold. What's nice about your family home too is if you don't transfer it to your kids and just enjoy it, you have the other part of the Prop 19 that allows you to port over your low property tax or whatever it is. It may not feel low, but compared to a brand new property, it's seriously low.
Yeah.
And you can move anywhere in California.
Right.
So you need to have those, keep those options probably.
Okay.
You
Thank
have to
you.
talk.
Yeah.
Good
Thank
question,
you.
Ellison. Thank you.
Thanks.
Terry, there's another question that I just texted over or put in the chat room. So if our goal is to pass along a legacy property that is not a primary residence, not a rental, the assessed value of this property is $500,000 and the fair market value is $2 million. If our goal is to keep the property value low and manageable for a low income earner to live as a primary residence, does it make more sense to transfer during owner's life or waiting for inheritance at death?
So if it's not a residence, it falls into the category right now of other property. So it doesn't have to be rented. I use that as an example because people mostly rent and create income from these properties. So in this instance, it's over the $1 million mark. And so probably, I mean, the one instance, if it is, it's not a primary residence right now, I think you'd have a real hard time. Whoever will be leaving it, the owner now, would have to make it a primary residence before they die to qualify for under the new rules. And also anything over the, I'll call it $1 million and change, because it will change over time. I think there's going to be an adjustment over that $1 million assessed value. Adjustment number will change over time, hopefully increase, I hope. And there might be a reassessment in this instance, probably for about $1 million. So that's kind of serious number for a low income individual. So you'd have to find other monies to manage it. A special needs trust is not the best way to do this either. I would, in this instance, I would probably suggest looking at using an irrevocable trust, where the goal is to get a step up in basis because it's probably a pretty big jump up. We'd like to carry over basis if possible, and get this to this individual, but one way or the other, it needs to be done before the change of date. Or just know that there's going to be a reassessment for a part of it, and maybe over time, now it seems like a pretty serious number, so there's going to be a reassessment for part of it. So see if that's doable financially, and make sure somebody moves into it. The owner moves into it beforehand and deems it a residence, claims it as a primary residence. That's how you kind of get around that. That's a good question. Sounds
Thank you,
like a
Terri.
law school question or a
Thank
bar
you.
exam question. Thanks.
We have plenty of other questions there if you're still willing to entertain them.
Sure, I'm here.
Thank you. We have a family cabin that my mother is a third generation owner. So if it gets handed down to me after the 16, will it be reassessed? What about filing Exemption 58 or Rule 58 in the next 3 years?
Did you say fight it?
No, filing. Sorry about that. What
Oh.
about filing, I guess, the exemption for Proposition 58 in the
So
next?
if it's not the owner who passed away and gave it to you, let's say a parent, if it wasn't their primary residence, the date of their death, or when the date of the transfer, if it's after the 16th of February, then it is not a primary residence. So there's no parent-child exemption. So again, like the last question, move in. No, have mama move in there, poor thing, make it a residence, and maybe that will work. If there are multiple family members that get this home, my question is, even if and then you have to live in it, you have to now live in it, the cabin. So I don't know if that's, the rustic cabin primary residence is your goal, but if one of you moved into it and let's say 4 kids received it, it might be reassessed as to the 3 kids that aren't living there. So this is one that it'd be very, very helpful to do some planning or transfer early and look at the, look to see what the fair market value is, the assessed value is. Like, I'll just give you an example. When my dad passed, my mom got a step up in basis for some property. So maybe it's not so bad to gift it to me now. I'll just stand in her shoes, but it was reassessed 3 years ago rather than 25 years ago. So that capital gain wouldn't be a problem if I needed to sell it down the road. And I still get the parent-child exemption. So that's a kind of an example of where there might be a straightaway transfer if one of the spouses or parents passed away and there's a step up in basis on those properties. Maybe just transferring it, getting the low property tax using your parent-child exemption, and just know that you didn't get the best carryover basis, but not a bad one.
Correct.
It's all a calculation and figure it out.
Now, Terri, how long do you have to live in the primary residence for it to be considered your primary residence? Is it a year?
I would say a year. You have to take the exemption. So a lot of people just say, I started, like for rental properties, converting it to a residence, you have to live in it the last 2 out of 5 years. That's for IRS purposes. For assessor, it's not clear. So I would give it a good year, and we need to, I would say, flesh out that particular question.
So you have to declare homestead as soon as you assume ownership.
So when you take ownership, you're going to let there's in a recorded document, it'll say, is this your primary residence? And it's not even declaring a homestead, but it is declaring when you record the document, is this going to be your primary residence?
I see.
But that is key, because I think they're not going to take exceptions. Like, oops, no. Unfortunately.
Do you have to own the property outright? I mean, it's no mortgage before you can make any of these trusts or title changes.
I'm not sure I want to answer that online.
Okay.
So I'll just give you an example. You have to look at the mortgage details. But if I inherited my mom's property that had a mortgage on it, there are certain laws that protect me from the loan being called and or requiring me to actually qualify for that loan as long as the loan remains current. There may be an exception to using the irrevocable trusts, but that's something to really look at the mortgage and get some good advice on it.
Thank you, Terry. Now, there was a previous legacy question of a non-primary house. If moving in is not an option, to claim legacy house as a primary residence because there's another existing primary residence, wouldn't there simply be a capital gain tax owed at the time of inheritance? I guess if...
So it's really about, what we're talking about is not capital gains at this moment, not income tax. We're really talking about, can you still raise your hand and get the exclusion and port over your low property taxes from parent to child for non-residences after this date? You will be barred from doing that. You have to raise your hand and take the exemption, however you're doing the planning, before the cutoff date. Thank you so much.
Thank you. Thank you. Well, I want to thank everybody for joining us today. I hope you found the value in the strategies that our speaker presented. Thank you, Terry, once again. I will be sending an email with the link to our YouTube channel with a recording of this event. So make sure you subscribe so that you can stay up to date to any of the seminars or webinars that we're putting together from Fresno State's the Institute of Family Business. Don't forget to become a member. Your contributions make seminars like this possible. And you can always visit us at fresnostateifb.org.